we have a conciliation. Apart from this conciliation, we have this arbitration. So apart from conciliation, we have arbitration process also. So far, Vigilance Organization has never investigated any arbitral awards. For the first time, we have investigated certain arbitral awards. We found that there were errors in the award which could have been avoided, but the prime reason is we could see the lack of awareness regarding the relevant rules or the case laws, as a result of which arbitral awards which should not have been given were given in favor of the firm. So we thought that we could make a presentation out of it, highlight the areas where we have erred, and also cite the relevant case laws or the relevant procedures or rules available in GCC as well as Act, and to create awareness among the presenting officers and other officials. So with this brief background, we will go into the PPT. So arbitration is governed by GCC, the Act, as well as judgments of honorable high courts. So general conditions of contract, GCC mandates invocation of arbitration process to settle the disputes. So we can say that the arbitration process is governed by GCC. In case of stores contract, it is governed by IRS conditions of contract. Apart from that, we have an exclusive act for this purpose, namely Arbitration Conciliation Act 1996. The act has been amended thrice so far, once in the year 2015, next in the year 2019, and finally in the year 2021. And we are also bound by the judgments of honorable courts. Okay. The PPT, some other PPT. 211.
Yeah, I will complete.
Yes, sir, definitely. So as per terms of GCC, any of the parties to a contract can go for arbitration. So it means that railway also can initiate arbitration. Excuse me. Okay, yeah. So these are the topics that will be discussed today. These are the areas where we found that we have not presented the case in proper manner, as a result of which we lost the case. So let us go into the topic one by one. First thing is pre-reference and pendant rate interest. As you know, any award will have two components. Apart from the award component, it will also have interest component. So this interest can be granted by the tribunal for 2 periods. First is pre-award period, and the next is post-award period. Again, this pre-award period is classified into 2. One is pre-reference period, and another is pendant rate period. Pre-reference period is a period from the date of arising of dispute till the date of appointment of tribunal, whereas pendant rate period is the period from the date of appointment of tribunal till the date of award. So pendant rate, again, it's a Latin word meaning pending the litigation. So we have this pre-award period, which counts from the date of arising of dispute till the date of award. Whereas post-award period, on the other hand, is a period from the date of award till the actual date of payment. Now, first, we will concentrate on this pre-reference and pendant rate interest. Next slide. First, we will see what is the provision in the Act. Section 31(7)(a) of the Act stipulates the granting of pre-reference and pendant rate interest by the tribunal. It says that the tribunal may grant award at interest at such rate as it deems reasonable on whole or any part of the award amount for the whole or any part of the period between the date on which the cause of action arose and the date on which the award is made. That means a tribunal is free to decide the rate of interest with regard to this pre-reference and pendant rate period However, the key word here is unless otherwise agreed by the parties. That means if the parties in the contract have agreed to the contrary, that no interest, no pre-reference or pendant interest is payable, then the provisions of this act will not be applicable and the tribunal cannot grant any pre-reference and pendant rate interest. So this is the meaning of this section. Now let us see what is there in our GCC. Next slide. Yeah. So in case of works contract, we are gone by GCC, whereas in the case of stores contract, we are gone by IRS conditions of contract. Both GCC as well as IRS conditions of contract prohibits payment of any pendant rate interest. It says that where the arbitral award is for the payment of money, no interest shall be payable on whole or any part of the money for any period till the date on which the award is made. Now, if we read this section together with this act, now it is clear that a tribunal cannot grant any pre-reference or pendant rate interest. But we have seen that in 2 or 3 cases, a tribunal has given pendant rate interest also, which should not be there. Now let us see what are judgments of courts. Syed Ahmed Company with the state of Uttar Pradesh and others, Honorable Supreme Court held that if the contract bars payment of interest, the arbitrator cannot award interest from the date of cause of action till the date of award. Next. This is a railway specific case. Shri Kamachi DRM Palakkad. In 2010, Honorable Supreme Court held that where the parties are agreed that the interest shall not be payable, the tribunal cannot award interest between the date on which the cause of action arose to the date of award. Next. Shri Chittaranjan Maiti vs. Union of India in 2017, again, the Honorable Supreme Court was categorically held that if a contract prohibits award of interest for pre-award period, the arbitrator cannot award interest for the said period. And the latest judgment in Garg Builders vs. BHCL in 2021, Honorable Supreme Court held that when there is an express statutory permission for the parties to contract out of receiving interest, and they have done so, it is not open for the arbitrator to grant pendant rate interest. So, if we go through these things, one thing is clear. Next slide. It's clear that since the contractual provisions prohibits the payment of pre-reference and pendant rate interest, no pre-reference and pendant rate interest is payable in any arbitral award in railway contracts. So, as per section 31(7)(a) of the Act, the contractual provision has overriding powers, so which will be applicable in our cases, and so no pre-reference and pendant rate interest is payable. But no, also any railway contracts, because in GCC also we have the same provision. So, in any railway contracts, if the award is given, the award cannot contain pre-reference and pendant rate interest. So, I request all the presenting officials concerned and also the accounts department here that in case if there is any award with pre-reference and pendant rate interest, you can please take note of these things and we can rightly contest it before the Honorable Court. Now, having said this, let us see an interesting case. Next. This judgment was pronounced by Honorable Madras High Court just 3 weeks back. Union of India vs. RK Constructions. Honorable Madras, it's a railway case again. Honorable Madras High Court pronounced that pendant rate interest is payable despite the provisions available in the contract. It's quite contradictory, but they have their reasons. The presenting officer basically failed in putting for the view, pleading before the tribunal that no pre-reference and pendant rate interest is payable. So the judgment is very clear, but railways in their statement of defense did not even comment on the claimant's claim for interest and costs, leave alone seeking their jurisdiction. Actually, this case, it had 5 claims. In this case, we have terminated the contract and we have forfeited the security deposit. So this firm requested for arbitration. The grounds that the termination is illegal and whatever SD forfeited must be refunded along with interest, and some other claims is made. Totally 5 claims were made, and the tribunal awarded, which concluded that the termination of contract is illegal and the passed orders for refund of SD along with pendant rate interest. So this is the award given by the arbitrator. So against this award, specifically with regard to grant of pendant rate interest, we approached the Honorable Madras High Court. However, Honorable Madras High Court has dismissed our case on this ground because its Honorable Court has observed that we, while filing our statement of defense, did not even comment on the claimant's claim for interest and costs. We simply said that our termination is valid. So consequently, our forfeiture of SD is also valid. That's all. So we never commented regarding the claimant's claim for interest. So not only that, the parties failed to produce a copy of the full contract containing all the special and general conditions before the tribunal. So we neither pleaded before the tribunal that no interest is payable. We filed the GCC also. So on both ends we failed. So then court has observed that the tribunal decided the claim in the context of the pleadings and the evidence placed before it. Close this. So the tribunal decided the claim in the context of the pleadings and the evidence placed before it. See, in this case, we neither pleaded before the tribunal nor we placed evidence. So whatever we presented before the tribunal has decided. So Honorable Court said that in this case, whatever tribunal has decided is perfectly all right. And the last point is most pertinent here. The court observed that GCC should have been tendered in evidence and is not a statute that the tribunal could take cognizance of otherwise. If something is there in the law, even without your submission, the tribunal is supposed to take note of it and pass orders accordingly. But this GCC is not a law. It's a term of the contract for which the presenting officer is squarely responsible in ensuring that the provisions of GCC are put forth before the tribunal. But it was not done in this case. So it is, if someone has to be blamed, it is nothing but the presenting officer. So because of his failure in pleading before the tribunal and also the failure to submit the GCC before the tribunal, we lost this case and we ended up paying pendant rate interest also. So this judgment doesn't anywhere state that pendant rate interest is payable. It is only based on the facts of the case. So if somewhere the presenting officer has pleaded that no pendant rate interest is payable and he has submitted the GCC, then this judgment will not be applicable. This will be applicable when it's a failure on our side. When we neither plead before the tribunal nor cite the relevant provision of GCC, then this judgment will be applicable.
What led to the not presenting GCC?
We have to ask the presenting officer only. Must be, sir. So they were telling that it's an old case. They were telling that it is a 2007 case. So documents may not be available like that. But even GCC 2003, we are having the copies.
Without GCC?
No, sir. They are saying that papers are missing, not available. It's a 2007 contract, but still we have GCC 2003 onwards. Still we have the soft copies. We have very well presented it. But for some reasons it was not presented, and not only us, even the other party also did not submit the copy of this GCC. So based on the documents presented before the tribunal, they have awarded, so which the court didn't interfere. So I request all the presenting officers to take note of this judgment. It only reinforces our this thing that the presenting officer must put forth all the possible views before the tribunal. We should not leave anything untouched.
Everything is under arbitration.
Yes, sir.
Everything should have been preserved. Contract.
Yeah. Those facts of the case, sir, I cannot comment upon it. Court has observed that. Now only I came to know, sir. Now we will go through it. Just last week only I came across this judgment. So now I have to take this. So I request all the presenting officers to take note of this judgment and ensure that you are pleading before the tribunal against every claim put forth by the claimant. Whatever document you have, ensure that it is submitted to the tribunal, and we have to raise our counterclaim or defense against every claim put forth by the tribunal. Next. Now we will move on to post-award interest. So far we have seen pre-award interest, that is pre-reference and pendant rate interest. Even as per the provisions of the Act, if the parties have agreed to the contrary, then pendant rate interest is not payable. Now we will see what is the provision available in the Act with regard to post-award interest. Section 31(7)(b) of the Act stipulates granting of post-award interest. 31(7)(a) stipulated regarding pre-reference and pendant rate interest, whereas 31(7)(b) deals with post-award interest. Now it says that tribunal can grant post-award interest at the rate of 2% plus the current rate of interest prevalent on the date of the award, from the date of the award to the date of the payment. Now the current rate of interest offered by banks on fixed deposits is around 6%, 6 to 6.5%. So as per this, the tribunal can grant post-award interest at say 8 to 8.5%. It is up to the arbitrator to choose the appropriate bank. He may choose SBI or whatever bank. That is up to him. So the keyword here is unless the award otherwise directs. However, if the award directs certain interest, then that will prevail over this. So the arbitrator can say that interest at the rate 18% will be payable. So it will be final. We cannot say that it is 2% plus current rate of interest. it should be 8%, whereas you have ordered 18%. No, we cannot say that. So unless the award otherwise directs, this provision will apply. So that means the arbitrator can also follow this provision. Sir, whatever award says is final, sir. I will come to that, sir. If you go to the next slide, please. This 2% plus current rate of interest is included during the 2015 amendment. Prior to this amendment, that is the original version of the Act, 31(7)(b) read that interest at the rate of 18% per annum is payable. So now we can say that either the arbitrator is unaware of this amendment. So he was following the old Act and he must be granting 18%. But nevertheless, previous slide. Previous slide, please. No, sir, we cannot say, sir. Again, it depends on the award, sir. The award is directing that 18% is payable or 24%, something. It is final. So if the award, sir, yes, sir, it is up to him, sir. He can say it is 4%. We cannot also question him. He can even say 0%. Then also, so whatever award directs is final. If the award doesn't say anything, then this thing is prevailed. Next. So, in the absence of any specific order by the tribunal, to the contrary, the statutory provision for award of interest shall apply. That means, even if the award is silent regarding post-award interest, future interest, that is post-award interest, would be payable as per this Act. It is up to the tribunal again. Tribunal may, however, award interest at different rates. So, in that event, the order of the tribunal shall govern the award of interest. No, previous slide. Now, the difference between in the provisions of the Act between pendant rate interest and post-award interest is pendant rate interest. The section 31(7)(a) gives paramount importance to the contractual provision. It begins with unless the parties have agreed to the contrary. So that means if the parties have agreed that no pendant rate interest is payable, arbitrator tribunal cannot give. Whereas such provision is not there in 31(7)(b). It is silent about this contractual provision. That means we can assume that even if the contractual provision stipulates that no post-award interest is payable, as per the provisions of the Act, tribunal can grant interest. However, it is up to the tribunal. He can say that no post-award interest is payable, or he can say 18%. It is up to him. Even if he remains silent, then only this 31(7)(b) comes into picture. So this is the broad difference between both the provisions of the Act. Now we'll see what is available in our GCC. In case of clause 16(3) of GCC says this, and in case of IRS conditions of contract, para not 5, not 3 also prohibits. But nowhere it is stated that no post-award interest is payable. It only says that no interest shall be payable on EMD or SD or the amounts payable to the contractor under the contract. Normally, we overlook this provision. We will assume that this deals only with EMD, SD. It doesn't deals with arbitral award. But courts have not done so. They have interpreted this phrase amounts payable to the contractor under the contract in a broader sense and says that even the arbitral award will be falling under these terms. See, the award you are paying against, you are honoring the award, you are making payment against this award, which is nothing but amount payable to the contractor under the contract. So the court this in a broad manner and said that this phrase includes post-award also. So this is the difference between 31(7)(a) and 31(7)(b). As I said already, this 31(7)(a) award of pre-reference and pendant rate interest is subject to agreement between the parties to the contrary. So if the contractual provision stipulates prohibition of pendant rate interest, so nothing is payable. However, there is no such condition under section 31(7)(b) of the Act on award of interest for post-award period. However, honorable courts in several judgments have held that a provision in the contract prohibiting interest has to be construed strictly. So on the basis of such judgments, tribunal cannot award post-award interest since the aforesaid provisions specifically prohibit payment of interest. Now we'll see what are those judgments. Normally, as you know, in Article 141 or 142 of Constitution of India, a judgment pronounced by Honorable Supreme Court is binding on all the courts in the territory of India. It is not the case in the case of high courts. In the case of high courts, the judgment will be applicable only within the territory. Suppose I cannot cite a Madras High Court judgment in Kerala or somewhere else, whereas I can cite a Supreme Court judgment throughout India. Now, this case, it's a Honorable Guwahati High Court judgment. However, appeal against this judgment was dismissed by Honorable Supreme Court. So we can say that this is applicable. It said that when there is a prohibition in the contract for grant of interest, the arbitrator does not have jurisdiction to grant interest. Next. Again, Honorable Supreme Court in Union of India versus Crafters Engineering Leasing Private Limited in 2007 held that the clause in the contract prohibits payment of interest on the amount payable to the contractor under the contract. In assets, the arbitrator could not grant interest to the contractor. Well, most latest judgment, it is a railway specific case, Union of India versus Natarajan Enterprises in 2021. Honorable Supreme Court held that the contractor shall not be entitled to any interest. Now it is clearly written, neither pre-pendent rate nor future interest on the amounts due and payable to it under the contract in view of specific bar contained in GCC. So we have, since the Supreme Court judgment is nothing but the law of the land, we should follow these judgments. Until date, this judgment has not been overruled. So I request all the presenting officers and all the accounts department who are dealing with the arbitration that if there is any claim with regard to post-award interest, we should cite this judgment and make sure that no post-award interest is awarded. Now, in two of the cases where arbitral awards are pronounced, where we have investigated the cases, I requested the presenting officer to cite this case and plead before the tribunal not to grant post-award interest. So, in fact, they have accepted the same and they have corrected the award. So, even after pronouncing the award, there is provision available under Section 33, wherein which we can request the tribunal to correct the award. So, on that basis, we have requested the tribunal to correct the award, and they have accepted and they have corrected the award. Now, the award carries no post-award interest.
You said the act is having it.
Yes, sir, but court has overruled it. Act is overruled. No, sir, they said that if contractual provision is there, so it should not be given. But Act is silent about that. But it says that it is depending on the tribunal. The tribunal can say it is 0% award, so that will prevail. 0% interest, that will prevail. Now, there is a negative side in this with this judgment. It is favorable to railways, no doubt. But let's say I am the presenting officer in one case, the award went in favor of the firm. So I am annoyed with that award, but the award doesn't carry any post-award interest. So does it make any difference if I pay to the firm now or after 10 years? So my obvious interpretation will be not to delay payment, to delay in honoring the award. In such case, the firm may approach the High Court and file an execution petition. So we should not exploit this judgment. We should ensure that the award terms are honored. Only thing is, we should not make any post-award interest. So if there is any claim for that, we should ensure that the appropriate judgments, case laws are cited and the award carries no post-award interest. So we have come to this conclusion of this post-award interest. Since the contractual provisions prohibits payment of post-award interest, no post-award interest is payable in any arbitral award in railway contracts. So in any railway contract, neither pre-reference and pendant interest is payable nor post-award interest is payable. So in short, no interest is payable. That's all. So I request the accounts department here, suppose they receive any arbitral award for concurrence, you can cite these case laws. If there is any interest component in it, you can cite these case laws and propose for contesting against the judgment, against the award under Section 34, only with regard to these things. In one case, I can say, so far we have investigated 12 cases. Some are ongoing and some awards are pronounced. The total value of all this thing is 32.5 crore plus interest. So leave this 32.5 crores. If the interest component in one judgment, one award, the award amount is 2.16 crore. It carried pendant rate interest at 18% and post-award interest at 18%. Award was pronounced in the month of April 2022. So till July, means within 3 months, the interest component alone came to 85 lakhs because it had pendant rate interest also. So the more you delay in making the payment, the more you will be incurring loss, which you should not have incurred. So when we requested the arbitrator to correct this award, citing all these provisions, he said that he is not bound by GCC. He gave it in writing that he is of course a retired judge. So gave it in writing that he is an independent arbitrator and he is not bound by the terms and conditions of GCC, which is absolutely wrong. With due respects, he may be a retired judge, but a judge and arbitrator are not the same. An arbitrator is not a court of law. He may be a retired judge, but he cannot act like a judge. He is no different from either a retired or serving officer who is appointed as arbitrator. He is appointed as arbitrator. Arbitrator is a creature of the contract. So once he is appointed as arbitrator, even if he is a court-appointed arbitrator, he has to take into account the terms of the contract. He cannot say that I am an independent arbitrator. He has to take into account the terms of the contract and pass award accordingly. Yes, sir. Now we have gone to the court. I have informed the presenting officer and case has been filed in the court. So this is the scenario. If just imagine what will be the scenario in entire Indian Railways. How much interest would have been incurring? So in one case, I can see 85 lakhs was the interest for 3 months. So I request all the concerned to take note of this and ensure that.
1 month.
Yes, sir.
3 months we have waited for posting the approach report project.
Yes, sir. Award came and we have requested for correction of the award. So he said no. Then we have to oppose the court. So it took around 3 months.
You have executive department approached or?
No, I was informing the president of the executive department. I was directing those. So they have done. Yes. No, when it cannot be negative, no. Unless you have failed to put forth before the tribunal, then it is sure that the such component will be set aside. That's what I cited, no? 3 weeks back. Yes, sir.
Correct on. We follow the contract.
Yes, yes, yes. He has to follow the contract. He may be a court-appointed arbitrator with due respect, but he has to follow the terms of the contract. Okay. Same. No, I didn't cite the case. You're citing it. That's I am referring the same case only. Yes. That's all. No. Now you're saying RPN engineering. And that we got last month. I am saying some other case where a retired judge was appointed and he said it. Yeah, that's what.
You can.
Achha, so yes, corrected it. Okay, so now. Okay. Okay, so okay, good. Then now the third award is corrected now. Good. Okay. Yes, sir. Yes, sir. I can say this question. Yes. So we'll come to the next session. This thing, the topic now. It's regarding accepted matters. Next. So definition of accepted matters is there are certain matters which are out of the purview of arbitration. That means such matters are not arbitrable and such issues cannot be decided by arbitration. So such accepted matters are listed in our GCC. So in case of contractual provisions which are considered as accepted matters, you simply cannot refer it for arbitration. The logic behind this is, as you know, our clause 63 or 64 deals with arbitration in GCC. It says that in case of any dispute, you refer the case for arbitration. However, the same GCC tells that there are lists of certain areas, says that it is not arbitrable. So those areas are out of the purview of arbitration. That in fact there is no arbitration agreement between the parties with regard to the disputes in those areas. So as a corollary, disputes falling within those areas are not arbitrable. So only remedy available to the firm is in such cases he can approach the court of law. That's all. So he cannot ask for arbitration, the arbitrator to adjudicate the dispute with disputes falling in the purview of accepted matters. So whenever when we receive any request for appointment of arbitrator, the concerned executive department has to see if suppose there are 10 claims, you have to filter such requests. You have to see whether any such claim is falling within the purview of accepted matter. If it is so, we should inform the firm that it is not arbitrable, citing the relevant provisions. So prevention is always better than cure. Instead of allowing it to be adjudicated by the arbitrator and then going to court of law, it's better that we filter at the right time. Sir, some cases. Yes, sir. Some cases we.
Court of law, we normally argue.
No, sir. Actually, some cases there are two arguments here, sir. So on the day, PC sir said, if we don't say that it's an accepted matter, if we say that it's an accepted matter, you will go to court of law. There are chances that court of law may consider it. However, we have to follow the rules stipulated there. So once it is an accepted matter, you don't accept it. That's all. You say that it is not arbitrable.
General branch, put the name. Their view is better give.
No, sir. Yeah, yes, sir. So in cases.
What will
No, sir. Then I can also say that if you deny it, the firm can also leave it. There is no 100% chance that he will always approach the court of law. So why are you taking a law thing into your hand and deciding it? So as sir has rightly pointed out, in some of the cases, even though the executive department has stated that this purview is falling under accepted matter.
Back the file again, change my remark
Okay, okay.
for giving the award.
Okay, sir. Now, better that we don't allow these things under arbitration. Let him approach the court of law.
Finance branch has to be educated on this.
Yeah, yes, sir. So one thing is clear, if it is an accepted matter, you don't entertain that claim. That's all.
Yes, we give what happens. Is that the officer is held responsible?
No, sir, there are provisions, sir. Still we can fight. So I'm just coming into the level one. First filter out, that's all. So even if we don't filter out and it goes to arbitrator, even then we can fight. So I will come to that later, sir. Sir, these are different, sir. In every GC. Yes, sir. It is different. I will share that also. First, I will tell the law background, what are the judgments, sir, and then we'll go into those aspects. So next. Next. Issue. Okay, so several judgments of Honorable Supreme Court and other honorable courts are emphatically held that disputes falling within the purview of accepted matters are not arbitrable. So any dispute in respect of such accepted matters shall be referred only to a court of law. Next. So I am listed below some of the judgments here. These judgments state that if it is an accepted matter, don't refer to arbitration. Next. Next. So this.
Refer that accepted matters to arbitration.
Yeah, I will come to that, sir.
This administration decide that we should go against that.
Yes, sir.
report,
Yes, sir.
Because it is accepted matter.
Yes, sir.
There must have cases.
Yes, sir. I will come to that also, sir. So one such judgment is Food Corporation of India versus Recon Transport. Honorable court has held that
I know very well.
event of claims arising within the ambit of accepted matters, the question of assumption of jurisdiction.
Why am I?
Any. Please switch off your mics. Okay. So in the event of claims arising within the ambit of accepted matters, the question of assumption of jurisdiction by any arbitrator would not arise. Either with or without intervention of court. That means even if he is a court-appointed arbitrator, doesn't mean that he has every jurisdiction to adjudicate the dispute. Doesn't make any difference whether he is a court-appointed arbitrator or railway appointed arbitrator. Next. In several judgments, it was held that an award by an arbitrator over a claim which was not arbitrable as per the terms of the contract would be liable to be set aside. So in cases where the arbitrator has adjudicated the disputes falling under the purview of accepted matters and passed award, such award would be liable to be set aside because it doesn't have jurisdiction at all. Next. This is a railway specific case, GM Northern Railway versus Sarvesh Chopra. It implicitly states that there is no difference between a court appointed arbitrator or railway appointed arbitrator. It says that if the arbitrator is appointed by a judicial authority and such arbitrator allows a claim which is covered by an accepted matter, the award would not be legal merely because the claim was referred by the judicial authority to arbitration. So award would be liable to be set aside on the ground of lack of jurisdiction. So it doesn't matter whether he is a court appointed arbitrator or a railway arbitrator. Next. Another case, the claim covered by accepted matter was referred to arbitrator in spite of such reference having been objected to, and the arbitrator gave an award. So went to court, the honorable court has held that the arbitrator had no jurisdiction in the matter and that the reference to the dispute was invalid. So consequently, the entire proceedings were held as null and void. Next. Yeah. So now thing is clear. If the claims fall under the purview of accepted matters, such claims are clearly non-arbitrable and it shall not be referred to arbitration. So if there is any request of the contractor for referring to arbitration in respect of such claims, it shall be denied outrightly. Suppose we fail to do that, and the arbitrator is appointed, even then it could be pleaded before the tribunal that it has no jurisdiction to adjudicate such disputes after the appointment of tribunal. Now we see that. Next, as per section 16(2) of the Act, the presenting officer for railways shall plead before the tribunal that it does not have any jurisdiction on the claims falling within the ambit of accepted matters. So even after the tribunal is appointed, we can plead before the tribunal that it has no jurisdiction, citing the relevant provisions of GCC. However, such submission must be made not later than filing of statement of defense. So once you have filed the statement of defense, we cannot, as per section 16(2). And the next point also makes it clear that just because you have appointed an arbitrary tribunal does not mean that such pleading cannot be made before the tribunal. The claimant cannot say that you only have accepted our claim and appointed a tribunal. Now you cannot go back and say that the tribunal cannot have jurisdiction. He cannot argue that it has been explicitly stated so in the Act itself. Next, suppose.
Previous, can you?
Yeah, please. Please.
We're saying one side we are saying it's a certain matter not be
Refer to arbitration.
even
Yes,
if it is referred, you should not have jurisdiction.
yes, sir.
Now we are saying that before before filing the defense register,
Yes,
say
sir.
it is not happening.
Yes, sir.
That in any case the same law applicable, even if it is not referred, the matter need not be adjudicated by the arbitration.
Yes, sir. Suppose we, first point is we should filter those requests. We should not refer it to arbitration. Suppose we fail to do so and refer it to arbitration, a tribunal has been appointed. Even now we can state before the tribunal that it doesn't have jurisdiction.
The time period you are mentioning.
Yes, sir. Statement of defense.
Till the tribunal awards our jurisdiction is there.
Yes, sir. That's what
They are
I'm.
bound by the rules.
Yes, sir. I'm coming to that, sir. One by one. Next, suppose if the presenting officer of railways failed to plead before the tribunal within the stipulated time period, such submission can be made any time before the award is pronounced, duly furnishing the reason for such delay with the request to condone such delay. So 16.2 says that we should submit before the tribunal not later than filing of defense, statement of defense. Even if we fail to do so, even thereafter, till the award is pronounced, we can make such submission. But only thing is you have to furnish the reasons for delay and with the request to condone such delay. So as per section 16.4 of the Act, tribunal can admit such plea, such a related submission, if it has a view that the delay is justified. So then, let's say we have submitted before the tribunal. Now, as per section 16.5 of the Act, a tribunal shall decide on the plea. It can say, it can accept our view and can say that yes, it is an accepted matter. In that case, a tribunal will not adjudicate with regard to that claim. Or it can say that no, I have every jurisdiction. It can reject our request also. So as per section 16.5 of the Act, a tribunal shall decide on the plea, and where it takes a decision rejecting such plea, it shall continue with the proceedings and pronounce the award. But in such case, section 16.6 of the Act, we can file a petition before the competent court for setting such award under section 34 of the Act. Previously. So, to sum up, don't entertain the request falling under accepted matter. That's the first level. So you failed there and the tribunal was appointed. In the second stage, you plead before the tribunal before filing a statement of defense that the tribunal does not have jurisdiction. Suppose even there we failed. Then we come to the third stage. Anytime before making the award, before the award is pronounced, you can plead before the tribunal. Of course, citing the justification for delay and request a tribunal to condone such delay. If the tribunal doesn't consider our plea, it can continue the proceedings and pronounce award. But then we have every ground under section 16.6 to contest the award before the competent court. Suppose, let's say that we failed throughout, we didn't see, even at the time of appointment of arbitrator during the proceedings, now the award has been pronounced by the arbitrator. Can I go to the court under section 34 and plead before the court for the first time in this case that it is an accepted matter? Next. As per the recent judgment of Honorable Supreme Court in 2018, a party who has not raised any objections available to it under section 16 of the Act can raise for the first time such a plea under section of the Act. Now it has superseded several judgments which are pronounced in the past in 2002, 2008 and 2014. In these judgments, Honorable Supreme Court has held that once you lost the opportunity under section 16, you cannot take recourse under section 34. Overruling all these judgments, now the Honorable Supreme Court has held that even now, for the first time under section 34, you can raise this request. So it is clear that suppose we fail throughout, even after the award is pronounced, we can approach the court and file application under section 34 for setting aside the award. The grounds that it is an accepted matter. So this is the judgments of honorable courts, and now we'll see what are the accepted matters listed in GCC. So for this presentation, I have given GCC 2022. So I request all the presenting officers to look into the respective contracts. It may be old version of GCC 2003 or 2014. Only that GCC will prevail. Because in every GCC there will be some change. For this presentation sake, I have taken into account this GCC 2022. Doesn't mean that it will be applicable to every GCC. It depends on the case. It is case specific. So in GCC 2022, para 63.4 says that matters for which provisions have been made in the clauses, they have mentioned in certain clauses in GCC or in any clause of special condition of contract which is stated as accepted matter shall be deemed as accepted matters. That is matters that are arbitrable and the decision final and binding on the contractor. The last point makes it even more clear. Accepted matters shall stand specifically excluded from the purview of dispute adjudication board and arbitration. So this dispute adjudication board is a new concept introduced in this GCC only. If there is a dispute in cases where the tender value exceeds 50 crores, it should be referred to DAB first. You cannot straight away go for arbitration. It should be referred to DAB. Based on the outcome of DAB, you can go for arbitration. So even DAB cannot adjudicate the disputes following the proof of accepted matters. Okay, so let us see the clauses one by one.
Provision for conciliator.
Conciliator is also there, sir. Yes, sir. Conciliation is also there, but we normally don't resort to conciliation. Conciliation is also there. So clause 7J says that it deals with subcontractor. If the subcontractor performance is not satisfactory, railway may instruct the contractor to remove the subcontractor from the work. And he has to comply with that. All. And no claim of contractor whatsoever on his account shall be entertained by the railway, and this is an accepted matter. Yes, sir.
You requested the arbitrator.
Yes, sir.
Change the.
To correct. Yes, sir. Yes, sir.
Under what?
Section 33, sir. Section 33 of the Act. Sir.
We have the.
Yes, sir. Yes, sir. Yes, sir. I will discuss it in later. Sir. So this is an accepted matter. Next. Clause 8, it deals with the execution of contract agreement. Suppose you have issued LOA and the firm has submitted SD and you have intimated the firm that contract agreement is ready. So within 7 days of such intimation, he has to execute the contract agreement. Failing to do so shall constitute a breach of the agreement, and you are entitled to forfeit the full amount of SD and other dues payable. Not only that, he shall be debarred from participating in the retender for their work. So it is an accepted matter. Next, clause 18 deals with illegal gratification. The contractor shall not borrow or lend to railway official. If it is found to be done, railway can close this contract or rescind the contract, and the payment will be made up to the date of, for whatever work was done up to the date of termination. Only that payment will be made. No compensation will be made. Next, this is an important clause. It deals with meaning and intent of specification drawings. If there is any ambiguity regarding meaning or intent or any portion of specification or drawing or measurement or execution, whatever may be, decision of railway shall be final, subject to appeal. So the appeal must be made to the HOD concerned within 7 days. So in that case, whatever decision of HOD shall be final and conclusive, and it is an accepted matter. You cannot refer for arbitration thereafter. And one case I have been appointed as arbitrator. It deals with ballast collection. So the contractor has collected ballast. He says that he has collected around 7,000 metric cube. It was measured by SSC. It was around 6,700. Test checked by ADN. It is 6,500. Still less. So he signed the MBU under protest. And immediately he asked for remeasurement. Unfortunately, no remeasurement was done. Now, yes, requested for arbitration. Can I say that it is falling under accepted matter? I cannot. Because in this case, the appeal was made and no decision was taken on the appeal. If railways has communicated any decision, then that will be final, that will be an accepted matter. Now it is not fully completed. No action was taken on the appeal. So it cannot be construed as an accepted matter. Next. 39.1 and 39.2. Rates for extra items of work is not included in BOQ but available in SSOR. That rate only will prevail. And he cannot ask for higher rate. Clause 48. Clause 48 deals with offloading of part of work. It could be done only up to 5% of original contract value. It is an accepted matter. This is very important clause 43.2. It deals with no claim certificate. See, once a contractor has given a no claim certificate in favor of railway, the contractor will be debarred from disputing the correctness of items covered by the certificate, or he will be debarred from demanding a clearance to arbitration in respect thereof. But the keyword here is after the works are finally measured up. So before you made a final measurement, if you are asking for no claim certificate, that will not debar the firm from raising claims further. Normally what we do is work will be completed. First thing he will demand is refund of FD. So even before the final measurement is made, as per the procedure, we'll ask him to submit no claim certificate. So he will do so and we will refund SD. Then we will make all the measurements, record all the measurements, we'll give the final bill. He will sign it under protest and he will go for arbitration. We will always argue that he has given no claim certificate, so he cannot raise any claim thereafter. That is not so. Only after the works are finally measured up, if he gives no claim certificate, then he is debarred from going for arbitration. But we don't follow that. Immediately when the work is completed, before even measuring the final, taking this final measurement, when he wants refund of SD, we will ask him to submit no claim certificate. That should not be done. Yes, sir, but in cases where I have seen, he is immediately asking for refund of SD. So,
After measurement, sometimes it should not be passed.
right, sir.
Yes,
Okay, sir. Okay, and those cases, he can make the claim thereafter.
measurement is final.
Okay, sir. Once a measurement is made, there is no under protest, then it is final, sir. Okay, next slide, please. Because in one such case, a railway specific case, Ambiga Construction versus Union of India, Honorable Supreme Court held that notwithstanding this clause, the submission of no claim certificate, the contractor was entitled to claim a reference under the contract. It was held that such a contractual provision would not be an absolute bar to the contractor raising claims which are genuine even after submission of such certificate. In this case, the work was not completed. There was nothing to indicate that the work was finally measured. So before that, we called for this no claim certificate. So court observed that since the works were not finally measured up in this case, the submission of no claim certificate by the contractor did not prohibit him from raising his claims. And the court has also gave the logic behind this clause. It observed that clause 43 of 2 is meant to be a safeguard against frivolous claims after final measurement. So once final measurement is made and it is signed without trust, then if he gives no claim certificate, thereafter he cannot go for arbitration. But before, if it is done, before final measurement, if he gives any no claim certificate, that will not bar him from raising claims thereafter. Next. This is also an important clause, 45(1)(a). So contractor can object to any recorded measurements or classification on any ground within 7 days. And any remeasurement taken by railway shall be final and binding on the contractor. No claim whatsoever shall thereafter be entertained. Again, in my case where I am arbitrator, the contractor objected to the measurement. He has signed the MOU under protest and he has asked for remeasurement. But no remeasurement was taken by railways. So it is not an accepted matter. If the remeasurement was taken, then it is an accepted matter. Next. And there are certain statutory provisions which are bound to follow. Any disputes with regard to those things will be an accepted matter. So Payment of Wages Act, Contract Labor Abolition Act, Workmen's Compensation Act and Mines Act. If there is any dispute with regard to this, it's an accepted matter. So this clauses 61 and 62, right of railway to determine the contract, payment or determination of contract, and determination owing to the default of contractor, all are accepted matters in GCC 2022. I am told that this 61(2) is not an accepted matter in the earlier versions of GCC. So I request all the officers to look into the specific GCC, which is by which the contract is bound. Next. And 63(4), as Sir asked, we can also go for conciliation, but we normally don't go. Suppose the firm is asking for conciliation. If the parties reach an agreement and they sign a settlement agreement, it shall be final and binding. Thereafter, he cannot go for arbitration. It's an accepted matter. Next.
Cases.
Yes, sir.
Court is directly to go for the conciliation.
Okay, so yeah, we can conciliate. Okay, sir. So we can, conciliator can be appointed. So he will try to mediate, sir. He'll engage both the parties and try to arrive at an amicable settlement. It's acceptable with both the parties. There is no adjudication here and he will not pass any award. He will try for a settlement. Once both the parties have agreed for that settlement and signed it, then they cannot go for arbitration. So again, it deals with DAB. In case DAB decision is not challenged by either party within 180 days, it is considered as final and they will be barred from referring to arbitration. Next. So far we have seen the provisions in GCC which are considered as accepted matters. Now, not only that, we also have provisions in special conditions of contract, which is stated as accepted matter. Now, the stated as accepted matter is appearing in GCCs issued from 2020 onwards. Prior to this, any clause of special condition of contract is an accepted matter. That means even if you don't state that it is an accepted matter, if there is a provision in special condition of contract, by default it is an accepted matter. Now, the implication of this amendment is, if you are going to float a tender, make sure that in special condition of contract you list certain clauses and you specifically state that it is an accepted matter. Only then it will be considered as accepted matter. Okay, so now we have gone through this accepted matter. So one thing is clear: if it is an accepted matter, don't refer it to arbitration. Suppose we fail to do so, even after the appointment of arbitrator, we can plead before the arbitrator doesn't have jurisdiction. Even there, if we fail, we can always oppose the court. IRS conditions, I don't think any accepted matter is available, sir. Available. Achha, in reverse IRS, okay. September it is available. Okay. Prior to that, yes, it was not available. And this is the most important concept, limitation, is often overlooked. We have seen cases where claims bought by limitation were adjudicated and awards were given in favor of the firms. So the concept behind this limitation is the claim may be valid, but it must be put forth within specific period of time, beyond which it will be considered as time-bought claim. It cannot be entertained by anybody. The difference between accepted matter and limitation is, accepted matter only the tribunal doesn't have jurisdiction. You can always go to the court of law. Whereas in case of limitation, if invocation of arbitration is time-bought by limitation, neither the tribunal nor the court can entertain. So to put it simply, suppose if I borrow 10,000 from you, I gave a promissory note saying that I will repay this 10,000 with interest on or before this 30th November. I failed to do so with intention not to pay. You are approaching me. I make sure that I am not paying you. So only remedy available to you is to approach the court of law. You cannot approach the court of law after 10 years or 20 years. Even though you are right, your claim is right. Your claim is time-bought. So in such case, court will not entertain your application, even though it is valid. So such claims are called time-bought claims. So that is the definition of limitation. Limitation is nothing but the time period for bringing claims in bars legal actions after certain time period. There is a separate act for this called as Limitation Act of 1963, and this concept of limitation will be applicable to arbitration proceedings as per section 43 of Arbitration Act. That means if the claimant or the contractor is raising certain claims, such request for arbitration must reach the GM office within this limitation period. If it exceeds the limitation period even by 1 day, it cannot be entertained. Even if it goes to court of law, it cannot be entertained. So the request for arbitration must be made, or I could say it must reach our office within the period stipulated in the Limitation Act, failing which such a request shall not be entertained. However, if such requests were entertained and award is made, such arbitral award is against the fundamental policy of Indian law and is liable to be set aside under section 34 of the Act. I would like to share my personal experience here. Before joining Vigilance, I was working as Deputy CMO in headquarters. So there was this case. Contract was concluded in the year 1995. Dispute arose in that contract in the year 1997. So it was going on. In the year 2014, he made a request, the firm made a request for arbitration. So we entertained it, we appointed the tribunal. The arbitrator passed award in the year 2017 in favor of the firm, granting pendant late interest and post-award interest from 1997 till the date of the award and thereafter. Now, what are the errors in this award? First thing is, no interest is applicable. So the pendant late is outrightly prohibited, and post-award, of course, by virtue of our honorable court judgments, it is prohibited. But the basic error is, it is a time-bought claim. As per the Limitation Act, the time limit is 3 years. The starting point of 3 years, of course, will be different on case to case, and it depends on the facts of the case. But one thing is sure, the time period is only 3 years. But in this case, for the dispute in the year 1997, he gave a request in the year 2014. That is after 17 years, which is clearly time-bound by limitation. So as soon as the award is pronounced, we have approached the Honorable Madras High Court, and the Honorable Madras High Court has rightly set aside the award, observing that it is a time-bound claim. The arbitrator ought not have entertained this claim. So I request all the officials who are dealing with arbitration that if there is any claim, first, whenever you receive any request for arbitration, you see whether any claim is time-bound or whether the request itself is time-bound. If so, we cannot entertain the claim. Or if the arbitrator is appointed, even again, we can plead before the tribunal that it cannot be entertained. Next. So we'll see the provisions in the Limitation Act. As I said earlier, it is 3 years. But the starting point of 3 years could be anything among these three. So it depends on the facts of the case. This concept of limitation is a mixed question of law and fact. As per law, it is 3 years. The starting point of 3 years will be depend on the facts of the case. So the starting point could be from the date when the work is done, as per Article 18 under first schedule, or from the date which is fixed for performance, as per Article 54, or it could be the date from which the right to apply accrues. It is a stipulated provision in the Act. It could be anything among these three, for which we have to see the facts of the case. So now we'll see some of the court judgments here. It's a landmark judgment here. It is Inder Singh Rekhi versus Delhi Development Authority, pronounced by Honorable Supreme Court in the year 1988. It defined that a starting point for limitation for invoking arbitration would be the date of accrual of dispute. And the Honorable Court has defined what is a dispute. It said that a dispute arises when there is a claim and a denial and a repudiation of a claim. If there is no denial, there is no dispute. That means there is no starting point of dispute. That means the limitation will not come into play. So the applicability of this judgment is whenever the contractor raises any claim, you ensure that you reply to him immediately. So once you reply to him, citing all the relevant provisions of GCC, denying his claims, then your letter date will be the starting point of the dispute, because there was a claim and you denied it. So as per this judgment, there is a dispute and your letter will be the starting date of dispute. So from that date, within 3 years, he has to go for arbitration. If he failed to do so, then the claim is time barred. As simple as that. So by not retaliating, I have seen cases where the arbitrator, the contractors are smarter than us. When they take the contract, they made up their mind to go for arbitration and get further claims. So with that intention, they will be always recording everything in writing. They will be giving claims for which we don't respond normally. That should not be the case. We should respond immediately. So the sooner you respond, the sooner will be the starting date of limitation, this starting point of limitation. From that date, within 3 years, he has to go for arbitration. Otherwise, he lost his claim. That's all. And the last point even makes it clear. A party cannot postpone the accrual of cause of action by writing reminders or sending reminders. Suppose he has made a claim and denied it immediately. He cannot go on repeating it. Suppose he has made reminder letters 10 times thereafter, it doesn't extend the time starting date of limitation. Once you have denied it, your letter date will be the starting point of limitation. Just because he is giving reminders doesn't extend the date of limitation. So mere correspondence of a party by way of writing letters or reminders subsequent to the arising of dispute would not extend the time of limitation. So only thing is, suppose if there is a claim, if the contractor raises some claim which you feel that it is clearly barred as per the provisions of the contract, you immediately retaliate, citing all the relevant facts from GCC and deny the claim. That's all. Then another judgment, Panchu Gopal Bose versus Trustees for Port of Calcutta, 1993. Again, it depends on the facts of the case. In this case, the petitioner made his claim for the first time in 1979. It was denied on the same year. However, he has made a request for arbitration in the year 1989. Now it is a dispute arose in the year 1979, and there was a claim and a denial. So he would have gone for arbitration within 1982, but he requested for arbitration in the year 1989. So Honorable Court held that the claim of payment under arbitration was hopelessly barred by limitation. Next. Another case, J.C. Budraja versus Orissa Mining Corporation Limited, 2008. Again, Honorable Supreme Court held that as per the facts of the case, the dispute arose on the date when the final bill was prepared. Probably in this case, we would have prepared the final bill and you would have signed it under protest. So that date will be the starting date of dispute. From that date, within 3 years, it would have gone for arbitration. In this case, he didn't do so, so it was rejected. Next. This is Honorable High Court of Delhi judgment. In the year 2014, Municipal Corporation of Delhi versus Gurbhajan Singh and Sons. As per the facts of the case, the work was completed in the year 1994. So the cause of action arose in the year 1994. So it was given a request for arbitration in the year 1997, but it was filed in the year 2000. So it was limited, failed in the question of limitation. Next. And this was the case I was citing to our sports case, Union of India versus Amco Traders. The court observed that the question of limitation is required to be considered by the court or tribunal, even if the plea is not specifically raised. But in the earlier judgment regarding pendant rate interest, I said that it is the role of the presenting officer to put forth the claim. Is it not contradictory? On one hand, the Madras High Court says that it is the role of the presenting officer. If he fails to put forth the claim to put forth the defense, whatever the decision taken by tribunal will stand. But here the court says that even if the plea is not specifically raised, it must be considered by tribunal. Is it not contradictory? Exactly, sir. Difference is limitation is an act, whereas your GCC is not an act. If there is an act, because ignorance of law is not an excuse, whereas ignorance of facts is excusable. So this is a law. Arbitrator cannot say that I am ignorant. So even if there is plea not specifically raised, a tribunal has to consider whether has to discuss upon this aspect whether any claim is time barred or not. Whereas GCC is not your law, it is only a fact for which the presenting officer is responsible. You cannot expect the arbitrator to be thorough of all our GCC. He has to be thorough in this legal aspects, yes, but not so with regard to GCC. So court has observed that even if the plea is not specifically raised, the tribunal is bound to consider this limitation aspect. It has observed that the learned arbitrator has not discussed the question of limitation or given a finding thereon in the award. Therefore, court held that it is evident that it is in disregard of limitation, so the award was rightly set aside. Next. 2021, again, Honorable Supreme Court in second Robert Controlling Court versus Ramachandra and Sons held that the claims were excessive time barred. Second, you see the facts of the case. After payments are made by the end of March 2003, claims were first raised by the respondent on 8/9/2003, whereas demand for arbitration was made first on 7/11/2006, which is 3 years and 2 months. So it's been 3 years. Now the date of dispute is 8/9/2003 when it was denied. From that date, it should be within 3 years. It should have been 7/11 or maximum 7/9 or maximum 8/9. It has made the request on 7/11, followed by legal notice for the same on 31/2010. So court held that the claims were explicit time barred. Next. Most recent judgment, it's a railway specific case again. Vishwamaru and Co versus Union of India, pronounced by Honorable Supreme Court in this April only. In this case, the court has held that as per the facts of the case, the starting point of limitation would be 3 years from the date when the right to apply accrued. In this case, he has made a request for arbitration after 32 years. The work was completed in the year 1982. He has made request for arbitration in the year 2014. He justified stating that he was in constant correspondence with the railways. He has made several requests under RTE and has submitted several, whatever we have given the reply under RTE, he submitted before the court. And he claimed that it is not a time barred claim because it was it was live. Just because some correspondence were constantly being made, he tried to prove the point that it is not a time barred claim, which the court didn't agree. Once there is any dispute, you should go for arbitration. You should make the request for arbitration, and the request should reach the GM's office within 3 years from the starting date. Failing so, your request for arbitration will be considered as time barred. During these 3 years, there may be some constant correspondence, but that doesn't matter. The claim for request, the date of receipt of request for arbitration within the 3 years from the starting date of limitation. Failing which it cannot be considered. So I request all the officials who deal with arbitration to consider this aspect also. I've seen in 1 or 2 cases, time barred claims were considered, arbitrators were appointed. First thing is arbitrators pronounced award in favor of the firm. Even the court of law could not entertain those claims. We entertained and firm got benefit out of it. Next. Now we come to the last topic, award violating the terms and conditions of the contract. Next. So especially in engineering cases and construction cases, more specifically, contractor. Sir, for arbitration also, sir, as per section 43 of Arbitration Act, 3 years, sir. And starting point will differ from case to case. If it's applicable also for arbitral proceedings as per section 43 of that. So, after completing the work, several claims will be put forth by contractors, such as compensation for delay in execution of the work, idling loss or additional expenses due to extension of currency, overhead charges, loss of profit, escalation charges, charges for extending the BG as well the currency of the contract. The modus operandi followed by them is this. Suppose the currency of the contract is 6 months. They will agree to that. They would not, suppose they have not been in a position to complete the work because of our issue, maybe we would not have given GAD on time, we would not have handed over the land on time, or the firm would have been unable to complete the work within the stipulated currency. So we will ask for extension of currency. Invariably, we grant extension under clause 17A2 of GCC, which says that no other compensation is payable other than the extension of currency. And we also make it clear that no increase in rates is allowed. The same rate, terms and conditions as per the original contract, original terms of the contract only will be applicable. So agreeing to this, he signs the rider agreement. And let's say the work gets completed in 2 or 2.5 years. So till such time he will keep quiet. He will do everything. He will complete the work. He will give this FVS, a final variation statement or final bill. Then he will sign that thing under protest and will call for arbitration, making all these claims. We will see whether it is clear that as per the terms of the contract, no compensation is payable. But in spite of that, the contractor will raise these claims. And in several cases, we have seen the arbitrator has also considered these claims and passed awards in favor of the firm. We will see whether it is right or not. Next. First, we will see the conditions of the contract. When we extend the currency of the contract under clause 17A, it is clearly said that no other compensation shall be payable. The rates, terms and conditions will be applicable. And we also say that no increase in rates will also be payable. Yes, ma'am, please. You have to deny, ma'am. You have to deny. See, as I said, there was a case where 17 years he has made, after 17 years he has made request for arbitration. Then we went to court and set aside the award. Yes, we have to go to the court.
Whatever they are denying, that should be within the time frame of the.
No, yes, I will come to that. No, I will come to that. That's most important. Okay. So apart from that, there is one more clause which we often overlook. Clause 43.1. See, 43.2 deals with no claim certificate, which is an accepted matter. 43.1 is not an accepted matter, but it is nevertheless it's a condition of GCC. It deals with monthly statement of claims. It tells that the contractor has to submit claims which he feels that he is entitled. He has to give a monthly statement of claims. Failing to do so, last statement makes it clear no claim for payment will be considered which has not been included in such particulars. That means once he failed to submit his monthly statement of claims, he cannot raise any claim thereafter. But in all these cases, no monthly statement of claims are filed. But at the time of final bill, he signs under protest and raises all these claims. If they have done so as per this clause every month. So this is also a term of the contract. Next. We will see some of the court judgments in this regard. 1985, the Honorable Court said that when the terms of the contract prohibited payment in respect of work over and above what is provided in the contract, and the arbitrator awarded certain amount, it was held that it was not open for the contractor to claim extra cost. That means there was no PVC in the contract perhaps, but still extra payment was made, so it was held to be not in terms of the contract, was set aside. Next. 1988, again, it is more or less similar to railway work only. The contract provided for the work being completed by the contractor at the rates stipulated in the contract in spite of rise in price of material and labor charges. And there were specific clauses in the agreement which barred consideration of extra claims in the event of price escalation. However, the arbitrator has considered such claim. So Honorable Court has held that the contractor having completed the work, it was not open to him to claim extra cost. And the award given by the arbitrator for extra claim was held to be vitiated. Next. This is a very landmark judgment. It is clearly defined the role of the arbitrator. Honorable Supreme Court in the case of Associated Engineering Course, Government of Andhra Pradesh, an arbitrator cannot act arbitrarily, irrationally, capriciously, or independently of the contract. His sole function is to arbitrate in terms of the contract. If he has travelled outside the bounds of the contract, he has acted without jurisdiction. As a result of which, such award could be set aside. Next. And again, 1996, Honorable Supreme Court has held that a liability of the respondent is limited as per the terms of the contract. Now, as per our GCC, our liability is nil. We say that no compensation is payable. So our liability is limited as per our terms of the contract. We are not bound to pay any compensation. Next. 1997. The arbitrator, being a creature of the agreement, must operate within the four corners of the agreement and cannot travel beyond it. More particularly, he cannot award any amount which is ruled out or prohibited by the terms of the agreement. If the contract is silent, then the arbitrator can award. It is not disputable. But when the contract expressly prohibits something, he cannot consider such claim. There's a difference between these two. Next. So Chenna Ramalingam Reddy is superintending engineer. Again, it is a Supreme Court judgment. It is more or less similar to railways case only. The relevant clause of the standard specification stated that no claim for compensation on account of delays or hindrances would lie. And when extensions were granted, it was made clear to him that no claim for compensation would lie. Despite that, claim was allowed by the arbitrator. So, Honorable Supreme Court has held that it was impermissible to award such claim because arbitrator was required to decide with regard to the contract between the parties. His jurisdiction was limited with the terms of the contract. Next, 2001. This is more applicable in the case of retired justices being appointed as arbitrator. In the guise of doing justice, we cannot award contrary to the terms of the contract. No doubt our GCC is one-sided. It says that whatever may be the thing, no compensation will be payable. No doubt it is one-sided. But it is not open for the arbitrator to say that your GCC is one-sided, so I will award, considering the principle of natural justice, I will award in favor of the firm. No, he cannot do. He is not a court of law. He is not a judge. He is only an arbitrator. Arbitrator is not a court of law. So he cannot go beyond the terms of the contract between the parties, and in the case of doing justice, he cannot award contrary to the terms of the contract. If the contract is silent, he can interpret it. However, when the term of the contract is clear and unambiguous, he cannot ignore it. So when in unambiguous terms you say that no compensation is payable, arbitrator cannot ignore it and say that in considering the principle of natural justice, I will grant compensation. No, he cannot do. Next. ONGC versus SAW pipes. This is a very landmark case. As per section 28(3) of the Act, then Act, arbitral tribunal to decide in accordance with the terms of the contract, and if the arbitrator decides in violation of the terms of the contract, it could be a ground for recourse and it is liable to be set aside. And the Honorable Court has held that if the award is contrary to the substantive provisions of the law or the provisions of the Act or against the terms of the contract, it would be patently illegal to interfere under section 34. Now, as a result of this judgment, the Act itself was amended. Prior to this amendment in 2015, as per section 23 of the Act, a tribunal to decide in accordance with the terms of the contract. Now, this in accordance with has been replaced by the phrase take into account. Next slide, please. Original version of the Act, section 28(3). A tribunal shall, in all cases, decide in accordance with the terms of the contract and shall take into account the trade usages. Now, with the effect from 2015, the Act has been amended, as per which the tribunal, in all cases, take into account the terms of the contract and the trade usages applicable. Now, it appears that the provision of the Act has been diluted because in accordance with means you cannot overrule it. Take into account it means you also consider it. But even then, you cannot ignore the express terms of the contract. When you are taking into account the terms of the contract, and as per the terms of the contract, no compensation is payable, which is explicitly written. So you cannot simply ignore it. Next. So 2005, this is again more relevant to retired judges. Tribunal is a creature of contract between the parties. The appointment of tribunal by the Supreme Court or a High Court would not alter the status of the arbitral tribunal. It will still be a forum chosen by the parties by agreement. The jurisdiction of the tribunal being confined to the four corners of the agreement, it can pass only orders with relation to the subject matter of the reference. Now, with regard to that case, when Honorable Justice has said that I am an independent arbitrator, I cannot, GCC will not bound me. It is absolutely wrong as per this judgment. He may be a retired judge with due respect, but he is still only an arbitrator. He is nothing but a creation of contract. It will not alter the status of the tribunal. There is no difference between a serving officer appointed as arbitrator or a retired officer appointed as arbitrator or a retired justice being appointed as arbitrator. They all fall under one category, it's arbitrators. That's all. It is not a court of law. He cannot ignore the express terms of the contract and pass any award in the guise of doing justice. Next. And this is one important judgment. Normally, in cases I have seen, the contractors, while making the claim for compensation, they resort to this Indian Contract Act because they know that in GCC it is clearly written that no compensation is payable. So GCC is of no use to them. So there is a resort to this Indian Contract Act. As per Indian Contract Act, if there is a contract between the parties and one of the parties commits breach of the contract, they are liable to compensate the other party who is suffering from the breach. In other words, the party suffering from the breach is entitled for compensation from the party who is committing the breach. So they will resort to this Indian Contract Act and say that as per the provision of the Contract Act, they will tell that railways has breached the contract by not giving the GAD on time or not handing over the land on time. So they will tell that railways have breached the contract. So as per this provision of the contract, I am entitled for compensation. Now this court judgment said that whether we can contract out of this contract act. On one hand, you say that as per Indian Contract Act, we are bound to pay compensation. But as per our individual specific contract, we say that no compensation is payable. This judgment decided whether we can go for such contract wherein we say that no compensation is payable, which is not as per the Indian Contract Act. In this case, the court has held that terms of the contract would prevail. No doubt there is an Indian Contract Act says that compensation is payable, but if the terms of the contract specifically bars payment of any compensation, that will prevail over the Indian Contract Act. It said that the clause in question in that subject case would bar the contracted entitlement to damages, and pronounced that the arbitrator in that subject case clearly misconducted himself in awarding compensation, which was rightly set aside on the ground that he has acted in excess of jurisdiction. So even if the contractor claims compensation under Indian Contract Act, even such compensation is not allowed. Next.
In one of the serving officers arbitration,
Yes, sir. Please, sir.
they have avoided putting the reference at the contract.
Yes, sir.
We went to court.
Yes, sir.
Court has given the judgment in favor of the court. That whatever the arbitrator has given.
Have we quoted this judgment?
Your praise.
No, then I have to see the case, sir, because I have.
No, it is serving officer. Headed by the one second.
We have to see the case, sir, because court judgment is clear that the terms of contract prohibit something.
So many court references. But where are executive when it knows something about legal?
Right, sir.
We are talking about law or
Yes.
legal. So totally reference under we are not much familiar.
Yes, sir. Yes, sir. Yes. I agree, sir. Yeah, I agree, sir. It is dynamic. Yes, as I discussed 3 weeks back, it was totally against. Yes, sir. No doubt they also have several judgments in their favor. We have to counter it.
No, what's happening is, we, as a presiding officers, we are getting very few minutes to
Yes.
read the
Yes, sir. Yes, sir. That is not your main work
very
also.
old cases.
Yes, sir.
Maybe 10 years old.
Yes, yes, sir. Yes, sir.
We will be there. We are not doing the practice. What has happened?
Yes, sir.
Maybe we present.
Right, sir.
There can be some documents available.
Right, sir.
But he is bringing a senior advocate.
Yes, sir. Yes, sir. So yes, sir. We always lose our confidence.
Fight with that.
Right. For him, it is a bread and butter.
Not
So
only
he will
that.
fight to the.
No, not only that. We are putting very good payment in terms of percentage.
It's more or less like this thing, race between the cheetah and this thing, stag.
So,
Stag will run for his life.
so for the presiding officer, only a routine.
Right, sir. No, that's what I observed in several cases, sir. Whatever cases we have studied, not even one case law was cited by our presiding officer. Whereas on the other hand, as rightly pointed out by sir, they are employing some senior advocates and they are giving big bound of things where they have pages of judgments. So obviously our confidence, we are losing our confidence, we are on the back foot. And more, this is not our only job. The presiding officer field work is more important and he will be damped with several cases. He doesn't have even time to go through the case. That's what, sir. No, we should, but the role of the dealing officials is becoming more important now. The presiding officer is not getting that.
From the arbitration side.
Sir,
So whatever the case comes in the beginning around the 5 we can handle arbitration.
right, sir.
So
They have designated cell.
express
Yes, sir. Yes, sir. Maybe we can.
better.
Yes, sir. That is better. Yes, sir.
Because,
Yes, sir.
it is some legal experts.
Okay, sir. Yes, sir. So where cases we have involved, sir, now we are also reiterating. We are giving in 500, 600 pages and now they are taking that.
Suggest to administration.
Yes, sir. Please. No, as sir said, there are several judgments which are in their favor, but I have tried to list out those judgments and differentiate how it is inapplicable to railway contracts. In this presentation, I'm covering it. Let's see, sir.
Some compilation of stuff.
Yeah, it is available, sir. I will come to that, sir.
Available to the railway.
Yes, yes, sir. Yes, I will come to that. I have made a part of the PPT also. And in the next case, Delhi Development Authority, Sara Sharma and Co. Again, everything points to the same thing. The arbitrator allowed without adverting to the relevant class of the claimant, which was set aside by the Honorable Supreme Court. Next. So, Delhi High Court judgments, MCD versus Gurbhajan Singh. The court will interfere with the award if the award is against the provisions of the contract. Next. This is a very landmark judgment, again held by Supreme Court. Associate Builders was the Delhi Development Authority. The tribunal must decide in accordance with the terms of the contract, after which this in accordance with has been replaced by taking into account. Now it allowed that if an arbitrator construes a term of the contract in a reasonable manner, it will not mean that the award can be set aside on this ground. So construction of a terms of contract is primarily for an arbitrator to decide, unless the arbitrator construes a contract in such a way that no fair-minded or reasonable person could do so. So when your contract expressly prohibits compensation, you cannot take it any other meaning. But if a contract is silent about compensation, then the tribunal can say that yes, you are able to give compensation. That cannot be questioned. But when your contract expressly prohibits compensation in plain and simple English, that no compensation is allowed, the arbitrator cannot different it or cannot construct it or interpret it in any other manner. Yes, sir. 17A2, it says that.
No.
Yes, sir.
Mention, you can take this one decision.
Yes, yes, sir. I will say, sir. I will come to that. Several court judgments are there in that. So 2019, Gammon India Limited is now. The tribunal has to proceed as per terms of the contract between parties. There are several judgments. I am restricting my presentation only with regard to these judgments. One thing is clear: the arbitrator cannot ignore the express provisions of the terms of the contract, even after amendment of the act, when it has been diluted instead of in accordance with, it has been diluted into taking into account. He cannot ignore the express provision of the terms of the contract. Next. So, when the terms of the contract strictly prohibits grant of compensation, the tribunal cannot go beyond the terms of the contract, cannot ignore the terms of the contract, and award compensation or loss of profit, idling loss, or whatever it is. But you have seen cases, and as rightly pointed out by sir, even courts have given judgments saying that the compensation is allowed. Now, in this case, only thing you have to see is whether we have argued correctly. Have we put forth our case laws? Maybe we would not have put forth. Now, we'll see next. We'll see judgments which are often cited by the claimants and their inapplicability to railway contracts. So, as we already discussed, a presenting officer is not the main role for him. He has field work, which is his main work. Apart from that, he has to look after presenting this case. So the role of the dealing officials becomes all the more important. They have to be thorough in all these cases, and they have to advise or guide the presenting, duly citing all these case laws. When we fail to do so, on the other hand, the claimant employs a senior advocate heavily paid, and he is coming with all judgments. Now, as a retaliation, we don't cite any case law. Now, we make the life of the tribunal very simple. See, if I am an arbitrator, if the claimant cites so many Supreme Court judgments, and on the respondent side there is not even one judgment, I will try to think that claimant's claim is right. That's all. No.
We are bound with the contract.
Yes, sir. But there should be equal argument also, sir.
Unless the judgments are passed.
Yes, sir.
We are fixed with the scope of this contract.
That is right, sir. But when claimant is citing several judgments, and we are not retaliating.
Anything related to this contract, and that much we can take into account.
Yes, sir. Yes, sir. So you tend to follow.
This knowledge, this vast experience.
Yes, sir.
For judgment of in this case.
So, sir, we should counter our argument saying that those judgments are cited by them are inapplicable in railway cases. Only then it will be. Yes, sir. Yes, sir. Yes, yes, sir. Only then that at least we must know. I'm coming to that, sir. It is so whatever judgments are cited by in cases wherever investigated so far, I've come across several judgments. I found that some judgments are mostly inapplicable to railway contracts. So I tried to bring it in a tabular form. We'll see next. One of the judgment often cited is PM Paul versus Union of India. They cite this para. Says that if you go through this para, anybody will come to a conclusion that yes, he is entitled for compensation, but it is not so. The Supreme Court judgment says that once it was found that the arbitrator had the jurisdiction to find that there was delay in execution of contract due to the conduct of the respondent was liable for the consequence of the delay, namely increasing prices. So if you go through this judgment, you will tend to believe that railway is liable to pay compensation. But the Reason behind this thing is we have to see the fact of the case. In this case, there was no clause in the contract which provided that the respondent would not be liable to pay compensation. That means in the subject case, the underlying contract was silent about granting compensation. So if it is silent, and the tribunal held that it can be given, it cannot be disputed. But it is not so in our case. The terms of GCC clearly stipulate that no compensation will be payable. That means this judgment will not be applicable to our case because the underlying contract in the judgment was silent. It is not so in our case. It is not applicable. Next, K. and Satyapalan versus State of Kerala and other. Again, it's a Honorable Supreme Court judgment. They cite this para. The arbitrator is vested with the authority to compensate the second party for the extra cost incurred by him as a result of the failure of the first party to live up to its obligations. But here, there was no express prohibition to giving of escalation, but was mere absence of escalation of clause. The Honorable judgment, the Honorable Court made it clear. If you go through this para, it will reply to source and query. In the absence of any price escalation clause in the original agreement, under specific prohibition to the contrary in the supplemental agreement, the appellant could have made any claim. This is the question for which the answer given is this. In the absence of any specific prohibition, the arbitrator is vested with the authority. But if you go to the next para, where there was no express prohibition in giving escalation, but was mere absence of escalation clause, and the government was at fault, the award of arbitrator giving escalation was held to be not improper. That means when the terms of the contract is silent, arbitrator can grant compensation.
The judgment of it.
Yes, sir.
I'm asking, is there any provision there? Arbitration Act?
Act, no, sir. No, sir, no, sir. Judgment is also law of the land, sir. It is also valid. It will vary, sir. Yes. It will vary. Yes, yes, no doubt, sir.
Applicable clearly, nobody can question any dispute at all.
No, sir. Arbitration Act doesn't say anything about that, sir. No, we have to.
Definitely created
No, yes, sir. But we have to follow the judgments also, no, sir. Judgments also we should take into consideration. No doubt, judgments are liable to change. Yes, sir. Yes, sir.
there are many disputes.
No, sir. Right, sir. You're quite right, sir. But the thing is, when this claimant is citing this judgment, I'm trying to find out that this judgment is inapplicable in our case. That's what. Because in this case, the contract was silent about compensation, which the court considered tribunal decision is valid. It is not so in our case. Our contract is not silent about granting compensation. So this judgment is not applicable to our case.
So, can consider, it cannot consider.
Yes, yes, sir. That is up to tribunal.
Yes, it's about that.
No, sir. It is. That's what, sir. If there is no express prohibition, mere absence of escalation clause, it is up to the tribunal. Even then, the tribunal say that no compensation is payable. You cannot question it. Then even the arbitrator can say that compensation is payable. Then also you cannot question it. But only when the contract is silent. If the contract expressly prohibits it, the arbitrators no other way. You cannot ignore the express terms of the contract and give award in contrary to it. But the Act doesn't say that, sir. We have only judgments. No doubt the judgments can be overruled, sir, but till date it has not been overruled. And I'm trying to convey the point that whatever judgment is cited by the arbitrator is not applicable to railway case. Next. Thank you, sir. McDermott International Inc. versus Burns Standard. This is often quoted by contractor. They claim that it is not necessary to prove the losses of damages. They will say that on account of extension, I have incurred 2 crores damage. That's all. And as per this judgment, it is not necessary to prove losses as damages. And it is up to the arbitrator to decide. He will adopt some formula. As you know, there are several formulas like Hudson formula, Eichley formula, Emden formula for calculating this overhead cost. It is up to the arbitrator to calculate the damages and it can be questioned. This is what the judgment says. Again, it is not applicable in our case because there was no clause in the contract between the parties which provided that the respondent would not be liable to pay damages. That means the contract is silent about awarding damages, so it is up to the arbitrator. In the absence of any clear prohibition for such damages, arbitrator can pronounce awards directing a party to compensate the other for the delay in work. But it is not applicable in our case because we have express prohibition. Next. Union of India versus Abdul Qadir, 2015. Again, the Supreme Court judgment says that in the event of one of the parties to the contract is unable to fulfill its obligations, which is direct bearing on the work to be executed by the other party, the arbitrator can very well compensate the latter. Here, why it is inapplicable is, in this case, the original contract expressly prohibited any compensation. However, when the respondent Abdul Qadir raised the claim of compensation while seeking extension of the currency of the contract, it was not denied by the appellant. We didn't deny that compensation is not payable in this case. So citing this, they are saying that arbitrator can very well compensate. Again, it is not applicable in our case because whenever we extend it under 1782, we make it clear that no compensation is payable. So this judgment is irrelevant to railway contracts. But they cite these judgments and the tribunal also considers these judgments because the para is just mere para. Okay, so if you just go through this para, anybody would believe that yes, the arbitrator can compensate. It is not so. You have to see the full facts of the case. Next, Tom Coase Engineers and Union of India again. They said that if the purchaser is responsible for the delay, in normal circumstances, he has to reimburse the damages cost on account of the delay. In this case, escalation clause was available in the contract. So when something is expressly available, arbitrator must act as per that. But in our case, it is not so. So it is not applicable. Next. So these are some of the judgments. They quote so many judgments. I have thought I could bring this thing to knowledge. Apart from this, also they quote several judgments. Only thing we have to see the entire facts of the case. We have to read those judgments in thorough. This McDermott International is around 90 pages judgment. You have the patience to read. You understand what does it mean. Look out for how it is inapplicable in our case. Then, if you cite that, if you counter it, then the arbit you make the life of the tribunal miserable. Whatever claim they put forth and whatever the judgment they cite, you counter it saying that those judgments are inapplicable. Apart from that, you cite the judgments which are in favor of you. Then the tribunal will be in a fixed mode. On one hand, you are proving that their arguments are wrong. On the other hand, you are citing some arguments which are in favor of yours. So these are some of the points. Yeah, last 10 minutes. So we'll come to the last part of this discussion. Next. So whenever there is a request for arbitration, you filter the request on the basis of these parameters. If there is any accepted matter, don't give it to arbitration. If it is failing in the question of law limitation, don't give it. And present your best arguments before the tribunal. Don't reserve something for a court. You bring everything in writing. Let the tribunal decide. And cite the relevant case laws. As Sarah asked me, there is a compendium available in Edison website up to compelling all the judgments which are in favor of railways. This compendium was created in December 2020, I believe. It is still available in Edison website. You can download it. It's a very beautiful article. Apart from this, net.
When you use a synopsis of the judgment or?
Synopsis, both the judgment in total as well as the synopsis, both are available there, sir. Edison has made this. Now, apart from this, in our homepage, we are also having this vigilance. Title knowledge updates. We have prepared write-ups in the form of FAQ. Not only regarding arbitration, but also this ongoing process. So in the form of FAQ, so I request all the officials concerned to go through this and make use of this and present your cases in a better manner. I have restricted my presentation only for a few topics, but there are several topics also. Apart from this, everything is available here. Next. Slide. So once an award is pronounced, you have two options now, section 33 or section 34. Under section 33, you can ask the tribunal to correct or interpret or grant additional award. Now this correction is only restricting you to correct any typographical error or any calculation error or something of that sort. With regard to interpretation, if there is a portion of the award which is ambiguous, you are interpreting it in one manner and the firm is interpreting in another manner, you can ask the arbitrator to give correct interpretation of that phrase. Apart from that, if there is some claim which was put forth but was never answered by the arbitrator, you can ask the arbitrator under section 33 to grant additional award. Additional award, the phrase is misleading. It doesn't mean that you can raise new claim. That is not so. The claims already raised or the statement of counterclaim already raised, if there is no response from the arbitrator, you can raise it under section 33. Next, the next point is section 34. You can often it is said that we are going to court for appeal. Appeal is not the correct word here. It is recourse against arbitral award. Next. There are two sections, section 34 and section 37. Section 34 is not an appeal, it is only a recourse against an arbitral award, because you have another section 37 which is an appeal. Suppose you got an award, you feel that, and again, you can file an application under section 34 only if you are of the opinion that the conditions listed, the award is in violation of the conditions listed in section 34. Just because I don't like the award, I cannot go to the court as a matter of right. It is not so. If any of the grounds stipulated in under section 34 is felt to be violated in the arbitral award, only then you can contest the award under section 34. With regard to metro cities, competent court is a high court. So here we have Madras High Court, that is a competent court. In other cities, we have a commercial courts. There is a separate act enacted in the year 2015 to reduce the burden of high courts. So suppose if it is in Kerala, the competent court is, lowest competent court is commercial court in Quillan or in Ernakulam. That's where you should file under application under section 34. If our application is dismissed, then the next step is section 37, approaching the higher court. Even again, if it is dismissed, last avenue is Supreme Court filing an SLP. Again, if the court, our application is dismissed there, we have no other choice but to honor the award. On the section 34, there is a time limit for filing an application, as DGM has rightly pointed out. It is 3 months. It is not 90 days. See, in law, 3 months and 90 days are different. So the application for setting aside the award under section 34 must not be filed later than 3 months from starting date. Again matters. Starting date is from the date of receipt of the award. It is not the date of signing of the award or not the date of forwarding the award. It is the date of receipt of the award. Because in one case, we have seen the arbitrators have signed the award on 24th January. It was forwarded by the presiding arbitrator to railways on 28th January. It reached the railways on 3rd February. Now, which will be the starting date among these three? 3rd February. But the presiding arbitrator officer misinterpreted it and assumed that the starting date as 24th January. He was preparing for contesting against the award. But since he misinterpreted the provision, he assumed that time limit is lost. So we paid the amount. The point is, in that case, the entire award, entire claim fall under the purview of accepted matter. So the award could have been straight away contested. And the worst thing is, the presenting officer himself, before the tribunal, pleaded that it is an accepted matter and he had no jurisdiction. Despite that, the arbitrator gave award, adjudicated the dispute and gave award in favor of the firm. That means the presenting officer clearly knows that it is an accepted matter. They have rightly contested it. But since he misinterpreted the provision, he assumed that he has lost the time and he recommended for making the payment, which we did. The award amount is 33 lakhs plus post-award interest. Post-award interest, again, we paid 2 lakhs. So you have accepted matter. So 33 lakhs is also wasteful expenditure. For the post-award interest, again, that is also wasteful expenditure. So whatever paid by honoring the award is a wasteful expenditure for us. So we have to interpret it in correct terms. The time limit, as I said, is 3 months, but it can be extended by further 30 days by the honorable court. Again, it is not 1 month. It is 30 days. So you cannot say that the time limit available is 120 days. It is wrong. The time limit available is 3 months plus 30 days and not thereafter. Once this time limit is expired, no court can entertain your application. So I suggest that we can have an internal time limit of 2 months. Instead of waiting it till the last case, wherever I'm asking the presenting officer to go for contesting the award, it is done only at the last 90th day or 89th day. So instead of that, we can develop an in-house mechanism wherein at the end of second month, we should approach the court. So role of accounts department is very important here. I suggest they restrict their concurrent time period to 2 weeks, not beyond that. Because in case I have seen they took 1 month, 1.5 months to concur the proposal. Concurring it, you don't take it more than 2 weeks. Legal take 1 week, not more than that. The procedure order is there. No, you cannot take 1.5 months. No, you cannot take 1.5 months for concurrence. And then you half the time period accounts department is taking. That is not correct. Yes, sir. Legal opinion and accounts concurrence both are compulsory. And with that, PHOD will give the final decision. I think it will come to GM also. No?
GM is the final.
Yeah, GM is the final authority.
Values. More than 25.
Okay, okay. So I think we will suggest it will develop an in-house mechanism. So once award is pronounced, you receive the award. Presenting officer should put forth his submissions within a week or so. Thereafter, it should get a legal opinion again within a week. Then let's say we have,
Vigilance issue here, like that.
sir.
That's why so vigilance issue.
Already
Acha,
issued,
acha.
sir.
Oh,
51 days time
Good,
limit.
okay, okay. Then it is okay, fine, good. So once we follow that, we at least we have 1 month breathing time. So we should not approach the court at the 90th day. So next, and apart from this, we have made a handbook that will be, we are proposing to release it tomorrow by GM sir. So this soft copy will also be made available on the website, and I have printed the hard copies also. I will ensure its distribution so that it reaches all the officials concerned. So I request you to make use of these things and put a best fight. No doubt. Yes, sir. The office is there, sir. And hard copies also. Also. Yes, sir. So no doubt they also have several cases, but this is an eye opener. So far, we never cited any case law. At least this is starting point. They will also have some cases in their favor. Once you habituate, you will develop the habit of going through what they say and countering it. So once it comes to arbitration, we should wear this legal hat. But no doubt we are technically strong, but we are always restricting our arguments to GCC. On the other hand, the firm is employing an advocate, and they are citing so many court judgments. We should also inculcate this. Please note down my number. If there is any clarifications required, you can always contact me. I try to help you out. Thank you. Thank you, sir. Thank you, sir. Any clarifications or any questions? Yes, sir. Yes, sir. Oh, yes, sir. We after. MSc, yes. As per MSc Act, you have to pay interest. That is the problem. 3 times the bank interest, bank rate. But as per our case, there is no interest.
So these are only if the MSc means we should not see this.
Yes, yes. This is only arbitration concession. MSc, there is a separate act.
This is an act is supposed to, but it is override.
It is overriding powers. It is a separate act.
It's not an act, but it.
We have to follow that. Laws of that.
Ah,
Okay. Thank you.